Leigh, feel free to begin.
Thank you very much. Well, good afternoon, everybody. My name is Leigh Hancher, and I'm the director of the European Union Energy Law area at the Florence School of Regulation. And today I'm hosting our 6 monthly update on the Court of Justice case law in the energy sector, or case law that's very relevant to the energy sector. And I'm very pleased to have with me today Matthew Levitt, who is my colleague at Baker Botts in Brussels, and my other colleague, Adrien de Hautecloque, who is also attached as special advisor to the Florence School of Regulation and is head of the cabinet of the president of the General Court. So we're in very good hands today, and we're going to kick off with Matthew Levitt taking us through a couple of cases that are not energy cases, but they're very relevant to understanding the interaction between competition law and regulation. So I'd like to first hand the floor or the screen to Matthew. Thank you.
Thank you very much, Leigh. Thank you, FSR EUI, for inviting me. So I'm going to try and share my screen. So bear with me, please. Okay, good. I hope everybody can see this. So as Leigh said, I'm going to talk about some developments in the case law on access to essential facilities. And I'm glad that Leigh made the sort of proviso in her introductory remarks that some of the cases that we're talking about are not actually energy cases, but they are certainly relevant to the energy sector. So, in fact, I'm going to talk about some cases which, well, begin with newspaper distribution, pass via ice cream, local loop unbundling in the telecom sector, and railways. But we'll make some concluding remarks to explain how they are nonetheless relevant to the energy sector. So the basic theme that I want to talk about is the way in which some of the case law coming out of the European Court has arguably narrowed the scope of application of the foundational case law on refusal of access to essential facilities or essential infrastructure, which was laid down quite a long time ago in a very important judgment known as Oscar Bronner. And arguably, the scope of application of that case and the conditions in it have been reduced in a way which expands the situations in which the imposition of unfair or restrictive access conditions can be condemned as an abuse. So by reducing the scope of application of the original tests, the court has, in effect, at least the effect of what it has done, has to expand the situations which can be condemned as abusive in relation to access to essential facilities. And this is especially relevant for undertakings which are subject to regulatory access obligations, or which have inherited a state monopoly position. And as we will see, what the court has done has essentially been to place companies of that kind, so companies which are subject to regulatory access obligations, or which are effectively successors of state monopolists, to place them in the second category and to relieve the Commission or any complainant of the obligation to show that access is actually indispensable, which is one of the original conditions relating to refusal of access. So that was really by way of introduction. And so just taking you through the case law, the foundational principles were established in the case known as Oscar Bronner, which I have just mentioned. And its facts are quite simple and easy to visualize. They related to a newspaper publisher that had established the only nationwide home delivery service in Austria. And a rival newspaper publisher said, well, I would also like access to this home delivery distribution service. It will be pro-competitive. It will enable me to compete with my rival newspaper. So I would like access to that home delivery service. And because it was the only one, the argument was that it was an essential facility. And the case ended up being referred to the European Court of Justice, which laid down really three tests, which I'll just summarize here. So the first question is the refusal of the service likely to eliminate all competition in the daily newspaper market? Secondly, is such refusal incapable of being objectively justified? And is the service in itself indispensable to carrying on the competitor's business? And by indispensable, they meant that there is no actual or potential substitute in existence for that home delivery service. So that third test of indispensability is the key one, which has been examined in the subsequent case law that I'll talk about. But before I get on to talking about some of the cases in regulated sectors, I think it's helpful to refer to another case, quite an old case relating to ice cream distribution. And so this case, which is known as Vandenberg Foods versus the Commission, Vandenberg, it's helpful to know, I think, is essentially Unilever. Sort of confusingly, the Unilever entity in these cases, which went on for many, many years, changed its name probably 3 times. But for these purposes, I think it's helpful just to think about Unilever, which was found by the Commission to be in many countries of Europe. This particular case related to Ireland. It was found by the Commission and subsequently by the General Court to be dominant in the supply of handheld impulse ice cream. And essentially what the case related to was Unilever's practice of making freezer cabinets available to retailers, small shops generally, without making any separate charge. So Unilever would hand over the freezer cabinet to the retailer, not charge them anything to rent the freezer, but say, you retailer can only stock Unilever ice cream in that freezer. And the case was prompted by a complaint from Mars when Mars started to develop its ice cream products. So it's Mars ice cream or Snickers ice cream, and found that it needed access to Unilever's freezers in order to get its products out there into the market. So it's a very long saga, but what I want to say in relation to Oscar Bronner is that one point that Unilever raised in its defense was that the case essentially, in its view, was an essential facilities case. And what the Commission was imposing on it and what Mars was asking for was access to Unilever freezers. And therefore was in essence a case about access to an essential facility. So that was the kind of case it was. And because it was that kind of case, the Commission was required to, but had failed to satisfy the indispensability test laid down in Oscar Bronner. But that argument was rejected by the General Court and then rejected by the Court of Justice for the reason that I've just set out here. And what the court said was that the Bronner was irrelevant because the Commission decision does not oblige Unilever to transfer an asset or to enter into agreements with persons with whom it has not chosen to contract. So Mars in particular. Mars is the company that wanted to get access to the freezers. As the Commission observes, unlike in the situation in Bronner, the freezer cabinets are not assets which Unilever retains for its own use, but their enjoyment is voluntarily transferred to independent undertakings which pay for the right to use them. And the payment was reflected in the amount that the retailer paid for the ice cream. So the important point here is that unlike in Bronner, there was no, in order to give effect to the remedy to the competition law problem, Unilever wasn't required to open up access where it had originally refused to make access available. it wasn't required to hand over any asset, transfer ownership in any asset, or to enter into any contract with Mars. The contracts were between Unilever and the retailers, and those contracts contained an exclusivity restriction, and it was that restriction which was the target of the Commission decision. And so that point that weighed so heavily in the court's mind about transfer of assets or entering into agreements, we will see come back in the very recent case relating to Slovak Telecom. So this was a case or a judgment given by the Court of Justice in March of this year, and relates to local loop unbundling in the telecom sector. And there were three practices which had been identified by the European Commission as being abusive. And without going through them, I set them out here on the slide, but without going through them, what they essentially consisted in was not a refusal of access, but the imposition of restrictions or conditions relating to the terms on which access would be granted. So the first related to the provision of information, the second related to the scope of the obligations, and the third related to setting various unfair terms and conditions in the unbundling offer. And when it came to examine those alleged abuses, the court began with what it regarded as a key principle, which we have seen reflected in the Unilever ice cream case, where it said that forcing a company in a case relating to access to an essential facility, as in Oscar Bronner, forcing a company to enter into a contract in order to grant access is detrimental to freedom of contract and the right to property. And also, importantly, risks disincentivizing investment by the dominant undertaking and by competitors. And the reason for that is that the concern expressed there is that if a dominant undertaking was automatically required to give access to any facilities that it had spent money investing in, developing for its own purposes, if it was automatically, routinely required to give access to those facilities to its competitors, then that would clearly discourage the dominant undertaking from making those investments in the first place. Why should it bother spending money if that would automatically help its competitors? And similarly, it would also disincentivize investment by competitors, because why should they bother investing in their own facilities if they would have an automatic right of access to the facilities of the dominant undertaking? So that's another important consideration. So those points there really explain why, in the court's mind, the Oscar Bronner conditions should be regarded as pretty exceptional, to be applied only in the most extreme situations. So as it went on to say, imposing requiring access to an essential facility interferes with basic rights, so the basic right of freedom of contract and the right to property. And so it's only justified where the dominant undertaking has a genuinely tight grip on the market by virtue of that infrastructure, and where such access is indispensable to the business of such a competitor, namely where there is no actual or potential substitute for that infrastructure. So they emphasize there that it's only in the most exceptional cases that interference with those basic rights is justified. So that's what the court said, really by way of principle. But then it went on to consider whether those basic points of principle were applicable in the facts, on the facts of the case in question. And what it said was that there is an important distinction to be made between an outright refusal of access, as in Oscar Bronner, on the one hand, and other situations where access is granted, but where the accusation of abuse relates to the terms on which access is granted. And they said the two situations, the outright refusal on the one hand, and the agreement to provide access but on terms which are regarded as abusive, are not the same and are not subject to the same test. And what it said was that in the situation where the dominant undertaking is accused of imposing unfair conditions of access, which was the accusation against Slovak Telecom, then the remedy to solve the problem doesn't require the dominant undertaking to give up its basic rights, to give access to property, to enter into a contract with someone that it has not chosen to enter into a contract with. Because in the situations where unfair conditions have been imposed, the dominant undertaking has already decided to grant access. So it's not a situation where access is being imposed on it. It has already decided to do so. And so the court said the measures to remedy the abuse would be less detrimental to freedom of contract and its right to property than forcing it to give access to its infrastructure. And the court then observed, which was also a very important part of the reasoning in the case, that Slovak Telecom was subject to regulatory obligations requiring it to give access to its local loop network during the entire infringement period. And that also meant that we weren't talking about a situation where Slovak Telecom could have refused to give access outright. On the contrary, it was required to give access by the regulatory framework that it was subject to. But that regulatory obligation left Slovak Telecom with a number of choices as to the way in which it would give effect to that obligation. In other words, it still had decision-making autonomy, and it exercised that autonomy by imposing unfair conditions. And it was those conditions which were the subject of the alleged abuse. And for that reason, the court concluded that the Bronner indispensability requirement did not apply. In other words, that the extreme exceptional circumstances in which the Bronner test is legitimate doesn't apply in a situation where the commission or the remedy to the finding of abuse involves some interference with basic rights. That was not the situation that Slovak Telecom was in, because it was subject to a regulatory requirement to give access, and the abuse consisted not in the refusal of access, but in the imposition of unfair conditions. Now, the final case I'd like to talk about is another recent case. It dates from November of last year. It's a case of the General Court, where the issue at stake was the removal of railway track, taking away 19 kilometers of railway track, which was found by the Commission to have had the effect of preventing a customer from using the services of a competitor. So this case it's a recent case. It's a little bit before the Slovak Telecom case. It's at the General Court and not the Court of Justice. But what is quite interesting about it is that it expands on and provides quite an interesting illustration of the point about incentives. So it doesn't address in the way that the Court of Justice did in Slovak Telecoms the point about the imposition of unfair conditions, the partial refusal of access, but it was very much about the impact of a regulatory framework to the question of incentives. And so I go back to the point which was important in the Court of Justice's explanation of the reasons for the strictness of the test in Bronner, that if access was imposed too readily, then that would run the risk of disincentivizing the dominant undertaking from granting access because its competitors could get access to its investments very easily, and it would deter the competitors from making their own investments. But what the court said here was that where the dominant undertaking is subject to a regulatory framework which imposes a duty of supply, a duty to provide access, then that argument doesn't apply. And so we don't need to worry about the impact on incentives. And they said that the regulation imposing the access obligation has essentially resolved that question. In other words, the question whether imposing an access obligation would deter investment, would disincentivize investment. And by imposing a regulatory obligation, has evaluated the issue and resolved it by saying, no, we are not concerned about the deterrent effect on incentives. We are imposing the obligation nonetheless. And therefore, when one comes to consider under Article 102, whether a dominant undertaking subject to a regulatory access obligation should be required to give access, and we consider the potential impact on incentives to invest, what the tribunal said is, no, we don't need to worry about the incentive issue because the regulatory framework has already essentially answered that question and removed it from the calculation. In other words, that part of the Bronner test does not apply. And the other thing I'd just like to pick up on is that the court also referred to the position of a dominant undertaking which occupies that dominant position as a successor to a former state monopoly. And so in that situation, the former state monopolist will be, the successor, the beneficiary of investments that would have been made during that period of state ownership, being placed on the position of a monopolist. And therefore, again, any potential concern about the impact of access on incentives to invest are effectively eliminated because the investments have already taken place, and they've taken place during a period of state monopoly. And so the conclusion that the court drew in that case was that the Oscar Bronner requirement of indispensability again did not apply. And the court applied a rather more straightforward foreclosure analysis based on the possibility that the practice, the removal of the track in this case, had an anti-competitive foreclosure effect. So just going on to my last slide, and just drawing some conclusions. So the first point is just to underline again that in the mind of the Court of Justice, there is no equivalence between an outright refusal and a constructive refusal. In other words, a refusal couched in terms of the imposition of unfair terms. And the slightly counterintuitive consequence of that, one might say, is that it would be harder to condemn an outright refusal of access as abusive than to condemn a constructive refusal of access. Or to put it another way, it would be easier to justify, at least because one would be able to have resort to the indispensability requirement. It would be easier to justify an outright refusal of access than a partial refusal of access. One thing that the court didn't address, and which is in some ways quite surprising, and it certainly was a point that was made by Slovak Telecom in its appeal, is a formal distinction between an outright refusal and a constructive refusal, one that really has any content or meaning. Suppose the situation where the dominant undertaking agrees to provide access, but anybody seeking access has got to pay what is clearly an excessive price, clearly not friend terms, a price that might generally be regarded as excessive, or imposes some other condition or term which is wholly unrelated and wholly unjustifiable. In what situation would that constructive refusal essentially amount to an outright refusal, because the terms are so unreasonable and so far removed from the commercial norm? It would seem to place an undue reliance on the form of the refusal. I think it is arguable, rather than the effect of it. If the effect of the conditions is that nobody could possibly agree to them. And then a final point is that obviously, because a lot of companies active in the energy sector are subject to regulatory access requirements of one sort or another, TPA requirements of one kind or another, and or are successors to statutory monopolists, our former statutory monopolists, then it is worth taking note of the implications of these two judgments, because it does mean that it may be easier to condemn conditions that have been imposed in relation to TPA or other forms of access. It may be easier to condemn those conditions as abusive in the light of these two judgments. Two sort of provisos to the proviso, unless the regulatory requirements eliminate all autonomy, then one might be in a situation effectively covered by state compulsion. In other words, the dominant undertaking had no choice as to the terms on which it granted access. And one would also need to consider whether the regulatory requirements applied throughout the infringement period, which might not also be the case. And so, I think just one final thought that, the scope of the European regulatory framework applicable in the energy sector, isn't the same in all sectors of energy and doesn't apply to everything that could be regarded as, activities in the energy sector. And so there are, there clearly are areas of activity, hydrogen may be one of them, where the kind of TPA requirements don't necessarily apply, and where the Oscar Bronner conditions may apply more readily than in other situations where regulatory TPA requirements are applicable. So with that, I think I probably filled my time. I'll stop and hand over to Adrien, but I'd be happy to take any questions later on.
Thank you very much indeed, Matthew, and thanks for explaining these cases so clearly and underlining their relevance to the hydrogen sector, which of course we're all waiting for the proposals from the Commission to come out as to how that sector will be indeed regulated, if at all. So it's very important to keep these competition cases in mind when looking at whatever will come out at the end of the year. So I'd like now to ask Adrien to take control of the screen, and he will turn to a different issue, very much an energy issue, but we'll move from competition law to institutional law and the very important Akwind case. So Adrien, the screen is yours.
All right, thank you, Leigh. Thank you very much, and I'm really happy to be here. And I will now, it's true, we will move from this very important competition issues to more institutional issue. I'm trying to share my screen. Is that working? Hello?
Yes, it's working, Adrien.
All right. Okay. Thank you very much. So yeah, for me, I will talk about the one of the recent Akwind case. We have had a series of cases concerning Acer and couple concerning this project Akwind, and there has been an order in another case concerning Akwind very recently, but I think it's worth coming back to that case, the T735/18 case, which is now under appeal, because I think it makes a lot of very interesting points about what is the role in the end of the Acer Board of Appeal. Very quickly, I will give you the facts of the case, and then we'll get on with the issue of the nature of the control exercised by the Board of Appeal, and I will do a few concluding remarks. Very shortly, the facts of the case. So the Akwind project is an interconnector project between France and the UK. The promoter wanted to frame it as a merchant project, so a non-regulated project, and to have that status of merchant project, they had to get the green light from the UK and the French regulator. The problem, they couldn't get an agreement with granting that exemption from certain provisions of the regulation, so they had to refer back the case to ACER. So ACER took the decision not to grant the exemption, basically for two reasons. First, because it was not risky enough, or at least the parties didn't manage to show that it was risky enough to justify being exempted from the regulated regime, and also because they could have qualified as a PCI, and it seems that they didn't seek this status. So they didn't get the exemption, so they appealed, Akwind appealed that decision before the Board of Appeal. And the Board of Appeal, so we all know what's the Board of Appeal. It's an administrative board who is reviewing the case before the case goes eventually to the European Court of Justice. And what was really interesting in that case is that they clarified what they think should be their level of review, and they explicitly pointed out that they think that their review should be the same. In terms of intensity, it should be limited review, especially limited to points of law or to the manifest error of appreciation. And so in this sense, it should be the same as the judicial review exercised by the General Court. So there was an appeal, and the General Court, end of last year, annulled the decision of the Board of Appeal exactly on that point. So the General Court framed, I think, the issue as a competence issue, because in the end, what we have to come up with is a system of review, both administrative and judicial, that ensures that there is sufficient judicial review of administrative decisions of the EU agencies. And so in the end, if there are 3 degrees, there is a Board of Appeal, so an administrative review, then the General Court, then the Court of Justice. Then what's the role of the Board of Appeal in this system? And for the General Court, the Board of Appeal should not have limited its review. That's what was the argument. Was that the board from Akwind is that the Board of Appeal cannot exercise the same control as the Court of Justice of the European Union, so in particular the General Court, and that it should not have limited its review to a manifest error of appreciation. So the court, in its reasoning, and actually sided with Akwind, first gave a few elements of context which I think are worth keeping in mind. First, the fact that if we have the need, that there is a need to have agencies at the level of the European Union for all these very technical sectors, we need to have the review that goes with it. And so in the end, they are very technical, these decisions, and they are shifting around billions of euros. So in the end, you need to have a thorough review, and that's why we have the Board of Appeals. So if the Board of Appeals do not grasp with the facts of the case, then you have to wonder exactly if, they play their role in the end, the architecture of control. And of course, the CJEU cannot have a full review of all these facts, which are always very, very technical. It also pointed out that it's clear from the regulation establishing ACER and the Board of Appeal that ACER should take all international measures to be able to achieve the objectives of the regulation. Because of course there's an argument about the resources which this Board of Appeals, because it's not only in the energy sectors, we have more and more of these Board of Appeals, which is a good thing, of course. But there's always an issue about the resources they can rely upon to exercise their review. So in the end, the issue is the interpretation of Article 19.5 of Regulation 713, which says that the Board of Appeal may exercise any power which lies within the competence of the agency, or it may remit the case to the competent body of the agency, and the latter shall be bound by the decision of the Board of Appeal. So at face value, it's very different from what we do at the General Court. So the Board of Appeal has all the powers available to ACER itself, but on top of that, when it remits the case, it can bind and can bond the decision which the agency will have to or direct or give guidance to what the agency will do after. So in a sense, the Board of Appeal can what can it do? It can overturn the decision and rule on the case. If the agency decision is upheld by the Board of Appeal, doesn't mean that the Board of Appeal is not doing anything. It has a role to clarify the decision. So it can uphold the decision, but clarify the legal and the factual grounds so that afterwards, the General Court, if there is an appeal, will have everything it needs to run the case. So in a way, the agency can expand a bit the decision, can give more facts so that there is the case in the end is easier to grasp for the EU courts. However, and that's something that we cannot do, the Board of Appeal has jurisdiction to annul or replace the decisions of the agency on the basis of technical and economic considerations. So it doesn't need to see that there is an error of flow, for example, or an error of appreciation to annul or replace the decision based on technical and economic considerations. So we see that they have to really go into the shoes of the agency, and so that their powers are fairly broad. So if the Board of Appeal chooses to remit the case to the agency, it can shape the decision taken by the agency. However, it's bound by the statement of reasons, and the agency then is bound by the statement of reasons of the Board of Appeal. And so I think also interesting, and which I think it's a bit obvious, but if the Board of Appeal was doing a limited review, and then the General Court would do a limited review, then there would be a problem of effective judicial protection. And I think there is really the main message, I think, is that we have to think about the control exercised by the boards of appeals in any area, in the full architecture of control. So limited review over limited review, at some point it doesn't get you really any review, and for sure the case law that has been developed in other area, for example in the chemicals area, is applicable to ESER. Then there's the General Court made a difference between the scope of review and the intensity of review, and I think that's an important point because what it means in a sense is that the Board of Appeal has to rule, but within the scope of the arguments raised by the parties, and we know that very well at the General Court. We have the same system. It's a system where the parties have to bring the arguments, then we rule on the arguments. But then, in terms of intensity, there's no limited review at the level of the Board of Appeal. There's full review. So, yes, a few conclusions. It's obvious that these agencies, in particular ESER, they have more and more powers. And which is probably a good thing, but then we need to create checks and balances, and a full system that works with a complementarity in the end between the Board of Appeals, the General Court, and then the Court of Justice, which rules essentially on points of law. So everybody has a role. The administrative board, and the judicial boards. If the Board of Appeal can step in the shoes of the agency, the General Court cannot do that, and so you get full review and a good system when everybody plays its part. We see this as an important evolution. I can I can mention, for example, the reform of the court statutes. I think somewhere in 2019 with the inclusion of a filtering mechanism. What that means is that limited to a few sectors, in particular IP cases, intellectual property cases. You know that in trademark, fine. Everything as regards trademark, we have an agency as Acer. It's UIPO. It's in Alicante, and there are boards of appeals the same way, and so there are a lot of appeals from the decisions of that board. And what has been implemented is a filtering mechanism between the General Court and the Court of Justice, and which means that the Court of Justice will hear appeal on these specific cases only if there is a problem with the integrity and coherence of EU law, because in the end, you don't need to have, it's always the same logic, and you don't need to have the same review at each and every level of administrative and judicial control. And so if that filtering mechanisms, which works, I think very well since it has been implemented, for sure, the level of review at the level of the board has to be up to standards. Of course, we can always wonder what this quasi-judicial means. So I think this case, in the end, is about defining what quasi-judicial or what is this administrative review that these boards are doing, because it's an hybrid sort of review, which I think makes it very interesting. And there we have a first set of answers about what these boards should do. The question of resources, of course, this is a big issue. It's not only about the resources, it's also about the procedure. It's important that the procedures of the Board of Appeals are up to standards and give the Board of Appeal, for example, the time to exercise a full review. Because if you have only a couple of weeks to take a decision, it's for sure very complicated to exercise the level of review that you should exercise. So the rules of procedures must be adapted to the level of control that is expected. The resources also at some point should be adapted to the level of control. We know that in some boards of appeals they have people working full time, the members of the boards. I know in Acer it's not the case, but it's also justified probably by the fact that they don't adopt that many decisions in the end. Because some boards of appeals adopt hundreds of decisions every year, which is not the case, at least so far with Acer. But at some point, probably there will be a need, if there are more and more decisions adopted by Acer, that the resources and the procedures are adapted to the level of review, even though what is in that case, of course, is under appeal. At this stage, so we will have to see what the Court of Justice is saying on that case. If the judgment is upheld, of course, I think we will have at this stage much more clarity regarding what the Board of Appeal should do. Maybe just as a personal idea, some cooperation among the Board of Appeal, because some have more experience. Of course, so far some have more resources. Some have. In their case law, let's say, or in the administrative practice, thousands of decisions, or there are only dozens of decisions. But if the judicial administrative architecture of control is going towards what is said in that case, for sure there will be a need to level up for some of the Board of Appeals. So I think, Leigh, I will stop there, if that's fine.
Oh, thank you very much, Adrien. Thank you. Sorry, yes, I had to unmute my microphone. Thank you very much for taking us through this really important case and highlighting, I think, some of the dilemmas with the system is creating. And as you rightly say, there are only a few cases at the moment, but their numbers are increasing. And there is, of course, an issue about the resources that a board of an agency does have at its disposal. I would like now to move to my two cases. I will attempt to share my screen, and I would like to talk through two recent cases, actually both from the General Court, and these are cases involving, on the one hand, an appeal by Client Earth on access to an internal review at the EIB. And the second case I want to talk about is on an ongoing state aid case from Lithuania. This is part of a real saga with, here we go, I hope it will work. And sorry about this, it looks like I might have a problem. I hope you can see it. So this, the second case is an ongoing saga where numerous cases have been reaching the court concerning.
Leigh, I'm sorry to interrupt you, but we can't see anything. We can see the presentation yet.
Okay, let me just share. It's hopefully going to come up now. Can you see it now?
Not yet. Can I help you maybe?
Yeah.
So do you already have the presentation open on your desktop?
Yes, I will send it to you. That's probably
perfect. But yeah. Okay, you can also try to click on share screen and find the presentation among the different options, and then click again on share.
Yes, it's I have a new PC and it's a new laptop, and it seems to
don't worry,
wants me to do all sorts of things before it will do that. So maybe if I have sent you them now, so maybe you will be able to.
For sure, I can share the slides as soon as I receive them. Okay.
Yeah, normally it works very easily, but it wants me to install something. I should have done that before. But maybe while we're waiting, I will start, as we have limited time. So I want to first look at the Client Earth case, and I will mention some of the implications that that case may have for the review of what's known as the Aarhus regulation, which is very important in the environmental sphere. And then I will move to the Achema case. So I'll proceed while we're just waiting for the slides to go up. What happened in this case is that Client Earth, which is a well-known NGO that is very active in using court procedures to realize, here we go, environmental goals. Thank you very much. So I don't know if I can move the slides myself. I'll have to see. Yes.
Yeah, I think you can't, but you can tell me next and I will move them for you.
So could we go to the next slide? Thank you. Yeah, so Client Earth then sought what is known as an internal review under Article 10 of the Aarhus Convention of a decision by the EIB, the European Investment Bank, to approve the financing of a biomass generation plant in Spain. This is the financing decision. The EIB refused the request for an internal review because they argued that this was not a so-called administrative act, and the focus of the Aarhus regulation is on administrative acts, and you can only request an internal review for those type of acts. The bank also argued that it was a decision that didn't produce any legally binding or external effects vis-a-vis a third party, such as Client Earth, and therefore they had no standing. And they also further argued that this financing decision had not been adopted under environmental law, which is what the scope of Article 21F of the Aarhus Convention applies to, and the Aarhus regulation implementing the convention into EU law. So if I could have the next slide, please. And just for those of you who might not be totally familiar with the Aarhus Convention, it creates a number of important rights based around 3 pillars, which is access to environmental information, participation in environmental decision processes, and access to environmental justice. And the convention is in turn implemented through the Aarhus regulation, which applies these 3 pillars to the EU institutions and various other EU bodies established on the basis of the treaty. So could I have the next slide, please? Now, the EU and the member states are bound by the convention as they're signatories to it, and they're required to establish then procedures to allow the public to challenge violations of environmental law in accordance with its Article 9.3. And in particular, it provides then that each party shall ensure, so every member state and the EU shall ensure that members of the public have access to administrative or judicial procedures to challenge acts or omissions by private persons and public authorities which contravene provisions of its national law relating to the environment. So it's important because we're talking about an admin procedure as well as a judicial procedure. And in this case, the internal review relates to the admin procedure, the administrative procedure. So if I could have the next slide, please. Now, who can bring these actions? Well, the regulation, the EU regulation stipulates that it has to be an NGO, which meets certain criteria set out in the regulation. And it can challenge what the regulation defines as an administrative act, which is any measure then taken by a community institution or body that has legally binding and external effects. So moving on now to the next slide. Klein Earth then used these provisions to argue that the EIB had misapplied the Aarhus regulation because it had not recognized that the financing decision was indeed an admin act, and they argued, as in many cases, that to the court that their decision was not properly reasoned. And they also argued, of course, that the case was inadmissible because it did not, the decision, the financing decision did not create legally binding effects for Klein Earth. Now, in January, late January this year, in fact, the General Court annulled the EIB's decision and held that indeed it fell within the scope of the Aarhus regulation and it should have been open to internal review. So going on to the next slide, it argued that the court held that EIB's argument that it required to be independent to carry out its financial operations was not a valid reason to refuse the internal review because it was clear that its refusal to give that, allow that internal review was based on one of the grounds of on the ground of inadmissibility was indeed an administrative act, so it could not claim this independence. It also said that, just to summarize, if it had wanted to lawfully base its decision on an additional independence ground, it should have withdrawn its refusal to grant the internal review and adopt a decision based on that ground. So that was a kind of a lesson to the EIB. So if it wanted to avoid scrutiny, it would have to do things differently. So moving on now to the next ground. Here, the court takes a very broad definition of the concept of an individual measure under environmental law. I don't want to repeat everything on this slide, but you'll see that it's a very, very wide definition and was capable of covering then the lending decisions of the EIB, which would inevitably address environmental criteria when assessing the eligibility of projects for EIB funding. So the court concluded then that the EIB's financing decision was a measure of individual scope adopted under environmental law, because it found that the biomass project satisfied the eligibility criteria of an environmental nature adopted by the EIB. So this is very important, because the scope then is recognized to be wide by the court. So next slide, please. And then finally, the court rejects the argument that the financing decision did not have any legally binding or external effects. And here the court relies on the general principles of EU law as to when an act of an institution produces legal effects on third parties. And here the court found that the decision created a definitive position on the part of the EIB on the eligibility of the project in question for financing, and therefore it produced definitive legally binding effects, including on the promoter of the project. So that meant that the court concluded that since Client Earth's request for internal review concerned the environmental aspects of the project, that request related at least in part to the definitive legally binding effects on third parties produced by the EIB's decision. And therefore, the financing decision fell fairly and squarely within the scope of Article 10 of the Aarhus regulation. And therefore, internal review should have been granted to an NGO such as Client Earth. So moving on now to the next slide, just to mention that the EU's compliance with the Aarhus Convention is something that is a bit of a matter of dispute between the EU institutions and the ACCC, which is the Aarhus Convention Compliance Committee. And one of the issues that's currently being discussed is to what extent the Aarhus Convention and the EU Aarhus regulation should also apply to state aid decisions. Are these administrative decisions affecting the environment? So can a state aid decision breach the EU law on the environment and therefore also be subject to both internal or judicial review in accordance with the convention? And this is one of the issues that's currently under discussion. The ACCC recommend that state aid decisions should be included. So if I could have the next slide, please. Just to remind you of this dispute, the EU position is that state aid decisions are adopted by the Commission in its capacity as a review body, not as an administrative authority, and so they should fall outside the scope of the convention. However, the recent decision of the Grand Chamber in Hinkley Point is now being relied upon by parties such as the ACCC, which issues non-binding opinions, or recommendations, to underline that state aid decisions are environmental decisions as well, that fall within the scope of the current regulation and should definitely be included in the scope of the amended version of that regulation, which is currently being negotiated. So if I could have the next slide, please. Just to recall that one of the commitments in the Green Deal is to improve access to citizens and NGOs on matters of administrative and judicial review. So to actually improve possibilities for review of decisions. So it's an important obligation, I think, now on the part of the EU institutions to live up to these Aarhus commitments. And we will see to what extent that play out when the current version of the Aarhus regulation. So the regulation implementing the convention is finally adopted. So this case is very important because if an NGO can claim internal, it is entitled to internal review, and that decision or an EU institution refuses to grant it an internal review, then it can appeal that decision because that decision is directly addressed to it. The NGO is individually and directly concerned by that decision not to grant it internal review. And this means that the NGOs can, although it will be a long and difficult road and an expensive one, but still it will mean that they have a greater chance of getting cases before the General Court and overcoming the very high barriers to standing that we know that NGOs face in the energy and the environmental fields. When they're looking, for example, to challenge state aid decisions, they're not addressed to the NGOs. So normally they don't meet the so-called plowman criteria. But if they can, first of all, use this internal review procedure, have that denied, then they can go to the court with a decision in their hands. And the court, the European courts will have to rule then on whether or not that internal review was wrongly denied. And if the internal review is wrongly denied, then of course it's easier then for the NGOs to challenge the underlying state aid decision. So it's an important case. It's of course subject to appeal, and we'll have to see to what extent it's followed by the Court of Justice. Now I'd like to move on to the next case. Can we jump along another? Sorry, we have to jump that slide. And that is the recent case concerning aid to support renewable energy production in Lithuania, case brought by Akwind, which is a large producer. And this measure that was challenged concerned a support scheme, which in turn took the form of a feed-in premium. It also took the form of compensation to electricity producers for their connection costs, and certain RES producers were exempted from electricity balancing obligations. Now, this whole RES aid scheme was financed, as is often the case, by a levy on final consumers. But this particular levy has been the subject of ongoing litigation over the last 5 or 6 years before the General Court and before the Court of Justice. And it's abbreviated as the PIS levy, so it's a sort of public service levy, if you like. And it's important to note that this levy it covers a number of objectives. So the levy is used to finance not just support for the producers of renewable energy, but also wider obligations for LNG terminals, for example, and various other activities. So the levy itself is problematic, and it's not purely limited here to financing RES production. This is an important aspect of the case. Now, moving on to the next slide. All electricity consumers are subject to this PIS levy, except under certain exceptions, electricity companies producing for their own needs, or where the electricity is consumed in CHP plants, or purchased by network operators to compensate for grid loss. Electricity produced by small RES producers also exempted. And finally, and interestingly, the electricity consumed by data processing and internet serving services. This was an interesting exception. Now, in the decision taken by the Commission, the first 4 exemptions were taken to be justified by the famous logic and nature of the system test, and did not therefore constitute state aid. So in other words, the reasoning of the Commission seemed to be, well, if you were going to impose a levy to finance renewable energy production, you shouldn't impose the levy on the producers of renewable energy. So that was it was in the logic and nature of the system to exempt those parties. And those of you who know state aid well will know that this is a test. This logic and nature of the system test is one that's rarely actually satisfied. So this was quite an unusual ruling. If I could have the next slide, please. It was an unusual ruling for a number of reasons. Achmea challenges the decision because it claimed that the Commission should have had serious doubts about the compatibility of this PIS scheme, and it should have opened the full formal investigation. The Commission, of course, having adopted a positive decision on the basis of just a preliminary investigation. So this case then was about serious doubts. The Commission should have not just closed the investigation on the basis of a preliminary investigation. So it should have had serious doubts under Article 107. And furthermore, the argument was raised that the method of financing this renewable energy scheme was discriminatory against both producers of electricity in other member states, as they didn't benefit from the premium they had to pay because the levy was imposed on imports, but they didn't get the benefit. And therefore, this contravened Article 30 and Article 110 of the Treaty on Customs Duty with equivalent effect, and 110 on discriminatory taxation. So moving on then, what was quite interesting in making the case that the Commission should have had serious doubts was that this was an old scheme that had actually been put into effect way back in 2011, but it was only notified to the Commission at the end of 2018. So it had been unlawful for a number of years when the Commission eventually authorized it in January 2019. And even then, the Commission took 3 years to find that it was either no aid for certain of the schemes and the exemptions under the scheme, and or compatible in the sense that it was the exemption for the data processing facilities was compatible. Now, often parties try to say, well, if the Commission took 3 years to reach a decision, surely it must have had serious difficulties in finding that the aid was compatible or not. But here the General Court mentions, I think, established case law that, okay, it might have taken a great deal of time, and that indicates the existence of serious difficulties, but that's not enough in itself. You have to go on and show something else. So that was not enough to argue that the Commission should have opened the formal procedure. So on the next slide, please, you'll see that what the Commission finds here not to be convincing was this so-called logic of the system test, because the decision is based, the court held, on an incomplete and insufficient analysis of the relevant national legal framework. And what's important there is that the national legal framework related to a levy called the PIS levy, which, as I mentioned at the beginning, it was imposed for a wide range of objectives and not just to finance renewable energy production. So the fact that that had been improperly assessed was enough to show that there had been serious difficulties. And you have to remember in these kind of cases, what we're looking at is the failure to open the formal procedure. So we're not supposed to be looking at an argument on the merits. What the parties have to substantiate is that they have standing to bring the appeal, and the appeal is about the failure to open the case for a formal investigation. And so it's not supposed to be required of the parties that they go into the merits of the decision. But that's a very difficult task usually, because you have to go into the merits to a certain extent to establish that there have been serious difficulties, or that the Commission should have met these serious difficulties. So it's often the case that you see parties arguing the merits and the courts accepting that to a certain extent this has to be done to underline that the Commission could not have just adopted its decision on the basis of a preliminary investigation. And what's important then is that the court adds here that the levy is illegal because it contravenes Article 30 and 110 of the treaty. So you cannot adopt a decision on the basis of a preliminary investigation when this method of financing the state aid scheme in question may be incompatible with the internal market. So the Commission should have opened the full investigation to examine the economic and legal effects which its financing may produce. So taking us now to the final slide that I want to mention is, so here the court goes through why the reasoning of the Commission is inconsistent, because this nature and general scheme and the logic of the system test has been applied in an inconsistent manner. So it seemed that, in fact, the exemption was going way beyond just the promotion of renewable electricity. So the reference system had been wrongly defined by the Commission. It didn't lie just in the promotion of res energy, but in fact, the exemption was applied to all producers of energy, including polluting energy sources. So these exemptions were actually unrelated to the support for the production of res electricity. And the final slide, sorry, I should just mention here. Could I have the next slide, please? On 110 and Article 30 and 110, the court recalls that these two articles do not provide for any derogations. So the prohibitions are absolute and general, and therefore it's impossible for the Commission to apply any form of derogation here. And what the Commission had actually done was it had recognized, of course, that this is problematic, and it had accepted a commitment from Lithuania that they would use the proceeds of the levy as paid by importers to finance new investment, new interconnections. And the court rejected that as a possible solution here, because these articles don't allow for such a commitment procedure. It's very important because we see that kind of commitment in a lot of capacity mechanism decisions where imported electricity is also subject to levies to finance capacity remuneration. And the problematic aspect of the application of 30 and 110 has been kind of fudged by commitments to build new interconnection. So I'll leave it there and turn the floor or the screen back to Adrien, who'll just check us through some final points here on what we can expect coming in the pipeline.
Adrien, we can't hear you.
Oh, sorry, you're right. Sorry about that. So no, it's good to finish the session to go a bit to look a bit forward. There are between probably 30 and 50 cases which are directly relevant to energy, and I'm not even counting cases like in the competition field, like the one Matthew discussed. So a lot of the cases are a lot of cases are relevant these days on what's happening in the energy sector. I will just focus on some of them and very quickly, and they will I'm sure give us the basis for further discussion in that forum in future instances. So very quickly, what I found I think interesting. First, of course, there is the quite already it's been dragging on for some time Opal case, where basically the Court of Justice this time we got the conclusions of the Advocate General earlier this year. We'll have to a bit clarify what's the substance of the energy solidarity principle, and this time it's in the context of the decision the Commission took back some time ago already, I think 2016, about the regime applying to Opal. So I think this one is an important one. A much more recent one, which I think is worth looking at and following up, I think we'll hear about that quite a lot, is the Turo lignite mine case, where the Czech Republic took Poland to court in the context of an infringement proceedings. So under Article 259 of the treaty, basically the idea there is that it's fairly rare that we have a member state taking another member state to court. Here, the Czech Republic considers that continuing to run the lignite mine in Turo in Poland is in a breach of EU environmental law, and in terms of prejudice, it seems that there is a problem with underground water. So if Poland continues to run the mine, then it seems that thousands of people across the border would be deprived of water. And I think it's more an environmental case than a pure energy case, but I think it's very interesting. And in an interim order, the vice president of the Court of Justice decided that Poland should stop extracting lignite in this mine, and I think we'll hear about these cases much more in the coming months. Then Commission Germany, I think very interesting. We got the opinion of the Advocate General on the 18th of March this year. There are a lot of questions. One concerns the concept of vertically integrated undertaking, and whether when you are let's say vertically integrated, but in different member states and outside of the union, you still have a conflict of interest. So that's an interesting question. I think you have a question regarding the unbundling provisions, other issues regarding the staffing of some of the entity, and I think more importantly, some questions regarding the powers of the national regulators as regard the setting of tariff. So I think this one is also worth following. In the competition area, at least two cases. First, the PGN-IP cases. There are two cases there. It's about the antitrust commitment that the Commission adopted regarding the conduct of Gazprom back in the days. So we got the hearings a few weeks ago. So I think this one, this old saga, it's interesting to follow. Something more recent, it's the appeals against the two decisions of the European Commission concerning E.ON and the E.ON and RWE deal. So it's still the beginning of the procedure, so it will take some time, but I think it's interesting to have a look. Then we have cases regarding the capacity remuneration mechanisms in Italy and in Ireland, I think. And now we got the opinion in the Tempus case on 3rd of June, where, if I'm not mistaken, the Advocate General proposed to annul the decision of the General Court, which had annulled to decision of the Commission. So I think an interesting case. So as you can see, we have all the Acer cases. They are not all listed, I think, but yeah, a lot of them are ongoing, and so it's the proof that there's an issue there about the growing number of cases. For the international trade aficionados, we always have a few anti-dumping cases in general. Looking at solar panels, we have also EU ETS cases. For example, recently, an opinion of the Advocate General was pronounced concerning ExxonMobil, which in the context of a preliminary ruling, was contesting the fact that they didn't get a free allowances. But so we always have cases concerning the EU ETS and anti-dumping, and so. But they are sometimes very interesting. The stated cases, I think, yeah. So just to finish on the stated cases, because as you know, we always have a lot of stated cases of relevance to the energy sector. I think one that is interesting, for example, is the Kappa case, where I think the hearing took place earlier this week, probably on Monday. It concerns a wind support scheme in France, where a group, including fishermen, are contesting a positive decision of the European Commission, supporting the development of offshore wind farms on the basis of the fact that, of course, this has an impact on their activity. So I think this was interesting. The Covestro case. So basically, there are, I think, about 40 appeals. And there are pilot cases, so I think this is probably the first one that will come out. So this is this old case concerning electro-intensive industries that got a special regime in Germany, and the Commission concluded, I think, that it was illegal state aid. Then there is something in nuclear. Autriche Commission, Austria Commission concerning Hungary, but it's not per se a follow-up of INCLE, but of course some of the issues are a bit similar. But there are other issues also in this case. So I think an interesting case again. Expo trading. It's not a stated case, but I put it there on that slide because there are some stated elements, in particular regarding selectivity, which are interesting. And expo trading is a free movement case, really in line with the in the line, let's say, of the old Alan Windkraft case law. So we got the conclusions end of last year. This one I think can be interesting. And very quickly now, the fossil fuel support in Ireland, Irish wind farmers. It's a saga. It's a follow-up. We had another case with an order adopted, I think, early in 2020. And so this is about fossil fuel support. Some fiscal aid are contested in that case. And to finish, there is this saga concerning the Lithuanian LNG terminal. We know there have been several decisions, and there are appeals on that. So a lot of interesting cases, and I'm looking forward to discuss them with you maybe another time. Thank you.
Thank you, Adrien. We have quite a few questions in the chat. We have to be brief, given the time is running out. The first question, I think, is directed to Matthew from Gordon Downey. And in the interest of time, I've just summarized the question and not invite the person to ask the question. I hope that's all right. And the question really is the Deutsche Telekom case still good law in your view, Matthew? So that basically competition law trumping regulation.
Yeah, thanks, Leigh. Yeah, no, I think the interaction between competition law and regulation is, still a really interesting and important one. And the basic principle is that it's actually quite rare that regulation entirely excludes the possible application of competition law principles. And most pieces of regulation, certainly true of the basic regulations, single market regulations in gas and electricity. recognize the scope for the continued application of Articles 101 and 102, where the regulation or the directives haven't expressly excluded them. So I mean, I'd say Deutsche Telekom is still good law, and what is interesting about the recent cases, Lithuanian Railways and Slovak Telecom, is that you could actually say that the regulation, far from excluding competition law, actually makes the application of the competition law principles even easier by eliminating some of the requirements that would otherwise apply. I think those cases actually illustrate the way in which regulation and competition work in parallel rather than in conflict.
Thank you very much. Yeah, I think this is one of the indeed ongoing puzzles of how to make sure they do operate in parallel. Yep. Moving then to Adrien, there's some questions coming from Peter Willis and from Mr. Petruzzo as to the impact of the new ACER, the wording in the new ACER regulation of 2019, which slightly changes the role of the Board of Appeal and seems to maybe limit the powers of the Board of Appeal to confirm or remit the underlying ACER decision rather than, as before, exercise any power of ACER. So the question is, do you think that makes a difference to the intensity of review that should be required?
Well, I think that's an excellent question, and of course I don't have a straight answer. I just shared my slide because my screen, because I was looking exactly at the difference of wording, and of course it's true that this is the older one. It has to exercise any power which lies within the competence of the agency, or it may remit the case to the competent body of the agency. So that's the older regulation, and in the new one, it may confirm the decision, or it may remit the case to the competent body of ACER. So there is a change of wording. When you look at the decision, at the judgment of the court, the first argument is that they look at the black letter of the law. So that's the first argument. But then there is a whole host of other arguments that allows the general court to decide in that sense. So honestly, I don't know. I think that's a very good question. Hopefully, we'll find out. But yeah, I think that's intriguing.
Okay. Yes. Not sure why the wording was changed. One has to delve into the legislative history, of course, which we don't have time to do here. And the final question was to me from Gordon Downey as to the comparison between the ruling in the Achema case that I went through, and the very recent AG opinion in the Tempest case, which Adrien also had just highlighted on his list of upcoming cases. The AG, of course, has recommended that the GC's ruling is annulled. But indeed, in the light of the Achema case that I reviewed, it does seem strange that many of the features of the system in the Tempest case were sufficient, at least in the Achema case, to raise serious doubts and to have required that the full investigation should have been opened. Of course, in the Tempest case, what was important for the General Court was the length of the pre-notification period, which seemed to weigh heavily on the serious difficulties assessment. But you also see in the Achema case that that's not in itself enough. There has to be something more. So we'll have to wait to see what the court finds for the Tempest case, which of course was an interesting ruling from the GC because it required the Commission to be much more proactive in its review of the UK system at the time. So it will be certainly interesting to see what the court makes of that case. Unfortunately, I think we're out of time. It's half hour. So I thank you all. I thank both our speakers, Matthew and Adrien, for the excellent presentations, and thank you also to all the participants. There are lots of questions that we couldn't answer. Some interesting observations as well as comments in the chat. Everything is available by way of recording. The PowerPoints are also available, and we will issue a highlights as well. So if this weekend you want to watch it all over again on YouTube, well, you might have to wait until next weekend. So you just have to watch football this weekend, and you can wait for the YouTube recording next week, I hope. So I hope you all have a wonderful weekend. I'd like to thank the FSR for hosting this event, and Elena for helping out and providing excellent IT services for us today. So thank you again, and we'll see you in 6 months to discuss some of the cases that Adrien highlighted in his list. So